Hello, my wonderful friends. I hope everyone is doing well and is having a great week. This one, I haven't really decided. I'm kind of like doing it as I go, but I think what I'm going to share is a couple of Darrell's witnesses. And this first one is Juan Marquez. And this witness that Darrell subpoenaed himself is also a victim. He is part of the Catholic community. And so, I mean, but like if this was our first time any of us hearing it, we'd be going, what? He's questioning his victims? But we know now that that's what seems to be customary for Brooks. And usually it doesn't work well for him. And it turns out to be another score for the prosecution. But let's see. And Mr. Marquez has an interpreter with him. So let's get with it. Oh, before we get started, I kind of forget to say these things. I am not an attorney, paralegal, psychiatrist, psychologist. I'm merely doing this for entertainment purposes, and if I can get educated by you all or vice versa, then that's good too. But this is like a commentary. I comment and react to videos, so there will be talking during it. So if that's not your thing, you can go over to Law and Crime or Court TV or any of your favorite news channels, and I'm sure they have this live where there is no talking, because I will talk, I will stop, but that's just what these channels do. But just a warning, so that way you know and you don't have to waste your time and go, oh wait, this isn't what I signed up for. So without further ado, here we go.
And then if Mr. Ryan would accompany the witness, this will be Mr. Juan Marquez being called by Mr. Brooks. Yeah, Jen, can we bring you guys here? Sorry about that. You can get another chair.
There's the man of the hour.
Mr. Brooks is calling Juan Marquez. Is that true, sir? Mr. Brooks, are you calling Mr. Marquez as a witness at this time?
Yeah.
All right, Mr. Marquez, if you would accompany the interpreter all the way to the witness stand.
Ill-prepared, digging in his boxes. Bailiff is going, Jesus, take the wheel. I need a drink.
When you get there, we're going to have the interpreter sworn first.
Do you swear that you will interpret truly, accurately, completely, and impartially in accordance with the standards prescribed by law, the Code of Ethics for Court Interpreters, and Wisconsin Guidelines for Court Interpreting?
I do. Certified Spanish interpreter Patrick Ryan.
Thank you.
And Patrick
Mr.
Ryan.
Marquez, would you please raise your right hand to be sworn by my clerk?
Do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sí.
Yes.
Please have a seat. Ladies and gentlemen of the jury, I have an instruction to read to you. No matter what language people speak, they have the right to have their testimony heard and understood. You are about to hear a witness in which an interpreter will translate for one of the witnesses. The interpreter is required to remain neutral. The interpreter is required to translate between English and Spanish accurately and impartially to the best of the interpreter's skill and judgment. The evidence you are to consider is only that provided through the official court interpreter. Although some of you may know the non-English language used, it is important that all jurors consider the same evidence. Therefore, you must base your decision on the evidence presented in the English translation. You must disregard any different meaning of the non-English words. You must evaluate interpreted testimony as you would any other testimony. That is, you must not give interpreted testimony any greater or lesser weight than you would if the witness had spoken English. Keep in mind that a person might speak some English without speaking it fluently. That person has the right to the services of an interpreter. Therefore, you shall not give greater or lesser weight to a person's translated testimony based on your conclusions, if any, regarding the extent to which that person speaks English. With that, sir, the first thing I will ask you to do is to state and spell your first and last names for the record.
Juan Marquez,
Juan Marquez,
Juan
Juan
Marquez,
Marquez.
Thank you. Go ahead, sir, you may question this witness.
Good morning, Mr. Marquez.
He didn't say good morning back. That's funny.
You were at the parade on November 21st, 2021. Is that correct?
Es correcto.
That is correct.
And do you recall who you were there with that day?
Con mi esposa y mi hijo.
With my wife and with my son.
And were you marching in the parade that day?
Sí.
Yes.
Do you remember who you were marching with? Was it a particular group?
Sí.
Yes.
Do you recall who that group was?
Sí.
Yes.
And at some point, you felt something hit your leg?
Something.
Es correcto.
That's correct.
And do you remember what that was?
Un vehículo.
A vehicle.
God. God. Help us.
And did you see the vehicle?
No.
No.
At some point, did you go to Freighter Hospital?
Sí.
Yes.
And were you interviewed by any law enforcement at that time?
Sí.
Yes.
Do you recall if it was regular officers or FBI?
FBI.
FBI.
Do you recall telling them that the truck was black? Grounds.
The objection is sustained as to leading. Please rephrase your question.
Do you remember what color you told them the truck was?
No recuerdo.
I don't remember.
That might have been the one thing. Sorry. I wonder if that was the one thing that got him. You know, he's looking over that police report folder and saying, he said it was the black. And he thought maybe he could get him on it. But, you know, these, not just Mr. Marquez, but many people those details are not going to be as important to them as they are to Brooks, because these people probably the main thing Mr. Marquez saw was the pavement. If he, as he got hit, because no doubt he fell, and I mean, he might have just seen the darn pavement. So, I shouldn't keep being amazed, but I am amazed by him with his weird hairline. Okay.
So it would be fair to say you don't recall seeing anything at that time?
¿Se puede decir que usted no se acuerda de nada en ese tiempo?
No.
No?
And did you at any time file a claim related to this incident?
¿En algún momento usted ha hecho un reclamo con respecto a este incidente?
No recuerdo.
I don't remember.
Do you know if anyone you were with filed a claim related to this incident?
¿Sabe si alguien alguien quien la acompañó si ha hecho un reclamo con respecto a este incidente?
No lo sé.
I don't know.
Hey, you're doing great, Brooks. Keep up the good work.
And would you consider yourself an injured party in this incident?
¿Usted se considera una parte herida, lesionada debido a este incidente?
Sí.
Yes.
Hell yes, he is.
Any reason why you wouldn't file a claim since you considered yourself an injured party?
Por el que usted
Grounds.
se considera que una persona no herida durante ese incidente, ¿alguna razón por la cual no archivaría un reclamo?
There's an objection. It's sustained as to the form of the question. Please rephrase.
Por favor, diga la pregunta de nuevo.
¿Me puede repetir la pregunta?
There's an objection. You don't need to answer.
No tiene que contestar.
Could you repeat the question, please?
Please rephrase, Mr.
Por favor,
Brooks.
diga la pregunta de diferente manera, señor Brooks.
It's kind of hard to rephrase.
Yeah, so just move on then.
Did you intend on filing a claim related to this case?
Objection.
De archivar un reclamo con respecto a este caso.
Hold on, there's been an objection. The grounds.
Sesión.
Your Honor, first of all,
Primero,
this witness testified he doesn't recall filing a claim, so I'm not sure what the relevance then would be of the question.
The question was, did he intend?
I'll sustain the objection as to the form of the question. Please rephrase.
Do you recall at any time filing a police report?
¿Se acuerda de un momento usted de archivar un reporte de policía?
Sí.
Yes.
Kiss me.
And was that with local law enforcement,
Eso
if
fue
you recall?
la agencia de policía local, ¿sí se acuerda?
No recuerdo.
I don't remember.
Did any law enforcement from that report follow up with you at any time?
¿Alguna representante de una agencia policíaca hizo algún tipo de seguimiento con usted en ese tiempo?
Sí.
Yes.
And do you recall what agency that was?
¿Se acuerda qué agencia te contrató?
No.
No.
Yeah, he's just digging now.
Do you recall at any time being notified that you could possibly testify in this incident?
¿Usted se acuerda que a un momento que le notificaron que en un momento usted podría testificar sobre ese incidente?
¿Me puede repetir la pregunta?
Could you repeat the question?
Sure. Do you recall at any time being notified that it was a possibility that you could testify in this incident?
¿Se acuerda que en un momento podría, si lo notificaron, que habría sido una posibilidad que usted podría testificar con respecto a ese incidente?
No.
No.
Were you ever subpoenaed in relation to this incident?
¿Lo citaron alguna vez a corte con respecto a ese incidente?
Sí.
Yes.
Do you recall who you received this subpoena from?
¿Se acuerda de quién recibió el citatorio de corte?
Del distrito de la oficina del fiscal.
From the office of the district attorney.
And do you recall when that was?
¿Se acuerda cuándo fue?
Un mes y días.
A month and a few days.
What the hell's he writing down? There's nothing to write down.
And following being subpoenaed, or strike that back. After receiving the subpoena, did you follow up with the district attorney's office at any time after?
Después de recibir entonces el citatorio, ¿recibió algún tipo de seguimiento por medio de la oficina fiscal después del incidente?
Sí.
Yes.
Do you recall whom you spoke with?
¿Se acuerda con quién habló?
Susan.
Susan.
Would that be referring to Attorney Opera, who is seated at this table?
¿Se refiere a Susan Harper que está sentado a esa mesa?
Sí.
Yes.
Okay, now what?
And were you at any time informed of a plaintiff in this incident?
Objection irrelevant.
Sustained.
No, la oposición.
You don't need to answer that
No
question.
tiene que contestar la pregunta.
Were you at any time notified that there was a plaintiff in this incident?
Objection
Grounds.
The objection is sustained. The
Zach is
witness
gonna
does
laugh
not need
again.
to answer.
Go.
Do you even know if there's a plaintiff in this incident?
Objection irrelevant.
The objection is sustained. The witness does not need to answer.
No tiene que contestar la pregunta.
Do you recall ever seeing, excuse me, do you ever recall, sorry,
He coughing because God doesn't like ugly. Forgive me, God.
Do you recall ever seeing or reading a complaint in this matter?
Entonces, ¿recuerda si usted vio, si le dio una acusación criminal de este asunto?
No.
No.
Going back to the actual incident, would it be fair to say that at the time you were very confused?
Volviendo entonces al incidente, ¿se puede decir que en ese tiempo usted estaba bastante confundido?
¿Me puede repetir la pregunta?
Could you repeat the question?
Going back to the time of the incident at the parade, would it be fair to say that you were confused at the time?
Volviendo entonces al momento del desfile, ¿se puede decir que usted estaba confundido en ese tiempo?
No.
No.
Any reason why you don't recall seeing anything?
¿Hay alguna razón por la cual usted no se acuerda de ver algo?
¿Me puede repetir la pregunta?
Could you repeat the question?
Any reason why you don't recall seeing anything?
¿Alguna razón por la cual usted no se acuerda de ver nada en ese tiempo?
No vi el vehículo.
I did not see the vehicle.
Solo pasó.
It just passed by. Sorry, the interpreter needs to make a clarification on his last response, if I can inquire.
Cuando usted dice que pasó el vehículo, ¿eso quiere decir que ocurrió el incidente o que el vehículo pasó por usted? Cuando usted dice pasó el vehículo o que pasó como ocurrió.
Ocurrió, me pegó y pasó.
Yeah, for clarification, the interpreter inquired if he meant the vehicle passed by or if the incident happened. The defendant, the interpreter, for clarification, the interpreter would like to say that he meant that it just happened, that the vehicle just hit him, rather than, I believe the interpreter translated what he said as it passed by. What he meant to say is that it actually happened, rather than passed by. So for that point of clarification, for the record.
Thank you.
A lot of dead air, I'm telling you.
Also, for clarification, just so we're clear for the record, you don't recall actually seeing the vehicle.
También, si vamos a estar clarificando por el acta, no se acuerda que vio el vehículo.
No.
No.
No further questions.
No más preguntas.
That was good, Brooks.
Any questions, Attorney Basie?
Briefly.
Brevemente.
Good morning, Mr. Marquez.
Buenos días, señor Marquez.
Good morning.
On November 21st of last year, were you walking with the Catholic communities of Waukesha?
El 21 de noviembre del año pasado, desfilando con Catholic Communities of Waukesha.
Es correcto.
That's correct.
Hold on. What was the objection?
¿Qué fue la posición?
I mean, you
You
already.
have to speak up. I couldn't hear what you said.
I have a code, so I can't.
Oh, poor
Mr.
baby.
Brooks, was there an objection so I can move on?
Yeah, yes, there
On
was an
what
objection.
grounds?
Grumpy pants.
I can't even remember now.
Nah.
Well, if you were objecting on relevance, it's relevant. His answer may stand.
It wasn't relevant, so I'll tell you that.
Mr. Marquez,
Okay, so yeah, He didn't even remember because he just spouts off things. Now, what I will recall is he did ask, was he with the group? But he never asked him what group he was with. So technically it was not asked and answered. So there.
If you
Oh, I wanted to stop for a sec and let you all know, if you think you hear thunder in the background, you do in fact hear that. It is what we call one of our, in Florida, a summer evening thunderstorm or shower. So hopefully it will not be too disruptive. But I want to let you know that. All right, let's continue on with this fool.
objection, please wait until I rule on the objection before you answer. Thank you.
Gracias.
Go ahead.
Adelante.
Sweet, did it answer the question?
¿Sí contestó la pregunta?
Sí.
Yes.
Thank you.
Muy bien, gracias.
You were with your wife and your son,
¿Estaba con su esposa y su hijo?
Sí.
Yes.
and your son's name is David Marquez?
Objection leading.
¿El nombre de su hijo es David Marquez?
Overruled, you called the witness, the state may lead. Go ahead and answer.
Conteste la pregunta, por favor. ¿Sí puede contestar?
What's that?
Go ahead and answer, sir.
Conteste, por favor.
Sí.
Yes.
You testified that at some point you were struck by a vehicle.
Objection.
Usted testificó en un momento que usted testificó que
Overruled.
era un vehículo.
You may answer.
Puede contestar la pregunta.
Sí.
Yes.
Did you have any warning before you were struck by the car?
Objection. Hearsay.
He'll never learn hearsay.
Le pongo la evidencia por referencia.
Overruled,
Anulada.
the witness may answer.
Puede contestar la pregunta.
No.
No.
Did you hear a horn honking?
Escuchó
Objection.
una bocina, un claxon.
Hearsay.
¿Está sonando el vehículo? Un claxon.
Overruled, the witness may answer.
Puede contestar la pregunta.
No.
No.
Sir, I'm going to show you what's been marked as State's Exhibit 161.
161.
Go ahead.
Adelante.
Can you see that picture on the screen in front of you?
¿Pantalla frente a usted? ¿Lo ve en la imagen?
Sí.
Yes.
And do you see the approximate area where you landed after the vehicle struck you?
Usted fue al área aproximado.
Objection leading.
Después de que el vehículo
Overruled, the state may lead, it's not their witness. Go ahead and answer, sir.
Adelante, conteste, por favor.
So when it's I can lead too if it's not my witness?
No. Well, hold on.
Shut up, Brooks.
There's been an objection, I'm overruling it.
Anulada posesión.
Go ahead and ask your question.
A ver su
The state
pregunta.
can do it they want.
Oh, Wayne.
Do you see the area in which you landed after the vehicle struck you?
Después de que el vehículo lo chocó.
Sí.
Yes.
I'd ask that this exhibit be admitted to evidence, which is 161, and published to the jury.
Objection.
Obrigado. Entonces, 161.
We can't even see who's what exactly is the state referring to.
¿Qué se refiere al Estado?
You can't even see who it is.
No veo quién es.
Just state your
Good Lord.
objection as overruled
Anulada.
Good God.
It's gonna be overruled.
because it's attempt to testify, but if the state could just ask a few more foundational questions, please.
Certainly. When you met with the state, did you review some video of the parade?
Objection. Hearsay.
Le pongo evidencia por referencia.
Not hearsay.
Overruled, the witness may answer.
Puede contestar.
Sí.
Yes.
And after reviewing that video, were you able to determine the area in which your body landed after you were struck by the car?
Objection. Hearsay and leading.
Overruled as to both. You may answer, sir.
Good gosh.
Entonces, se recibió, entonces,
Sore loser.
el choque del carro.
Your witness,
Determinó el área
Brooks.
de saber dónde su cuerpo quedó después de que el vehículo chocó.
Sí.
Yes.
And do you see that area on this exhibit?
Objection leading.
Overruled, the witness
said.
may answer.
Sí.
Yes.
I'd ask that this
Objection.
exhibit be admitted to evidence and published to
Shut
the
up,
jury.
Brooks.
Objection. What's the relevancy?
Your testimony.
The objections are noted, they are overruled, And Exhibit 161 is received. Permission to
Wow.
publish is granted.
A sour attitude. That's your witness, dude. Karma's a bitch, isn't it?
And it's indicated that that is now being seen in the jury box. Sir, the screen in front of you is a touch screen. Can you circle the area in which you believe you landed?
Objection, leading.
Overruled. The witness may answer.
He said where they believe.
Wow, he is
No, you
really.
don't.
The witness may answer.
Sí.
Yes.
Can you do that now?
I wish Brooks would get put out. He's talking back too much.
It gets fixed on.
Wow.
We can take a snapshot of that.
I don't know what Mr. Brooks just mumbled, but it's not his turn to ask questions. There was no objection. The jury will disregard that.
So in other words, she's saying, shut the fuck up. This is so disrespectful to the court, to the jury, and especially to the interpreter and this man who Brooks called as his witness and was his victim. Look at that look. Yeah. That's right. You get him, Juan.
And this would be Exhibit 161A.
He's still talking. I wish they'd send him out. Man,
And
oh
we'll
man.
screen capture that. Exhibit 161A has been captured. Are you moving that in?
I am.
And Exhibit 161 is received. 61A.
Thank you. And do you see anyone that you recognize standing in that area?
Objection, leading.
Overruled. The state may lead its
Yeah.
cross-examination of your witness,
So
sir.
I
Yeah.
can lead on cross-examination.
Shut up.
I direct your attention
No.
to 90611 sub
And I'll
3,
lead
sir.
on cross-examination.
I'm not going to answer that. Go ahead,
So
sir.
that's
You may
it's a
answer.
determination that you don't have to answer that.
Let this man make his testimony. You're so rude and selfish. He's just mad because he cannot come up with anything, and he always thinks there's some big secret that the state is against him. Again, it's just because they've had years of education and experience, and they know what questions to ask. It's that simple. Oh my God, I can't stand him.
If I don't understand something,
The jury will disregard the comments being made by Mr. Brooks.
it's your determination, okay?
Go
Wow.
ahead and answer the question if you recall it, sir.
¿Puede repetir la pregunta?
Could you repeat the question?
Yes. Do you see, actually, do you see David, your son, in that picture?
Objection. That wasn't.
Yes.
And is he wearing?
So my objection is not going to be noted.
Wow.
Objection is overruled. The state chose to ask a different question. That's fine.
And is he seated near some blue chairs, wearing a blue jacket?
Objection, leading.
Overruled. You may answer, sir.
Sure, sure. I
Yes.
told you about the leading
And
crap.
sir, is that you laying down, and you can see in this picture your legs, and they're hanging into the roadway?
Objection, leading.
Witness may answer. Overruled.
Sí.
Yes.
Now, is that where you were walking when you were struck from behind? In
Objection,
that
leading.
position?
Why does he keep yelling that after Sherry told him?
Overruled. You may answer.
Wow.
No.
No.
How far from the position that you recalled yourself to be at when you were walking did you land?
Objection, leading.
Why? What don't you?
Overruled. You may answer.
What do you not get about that fool?
Entre 15 a 20 pies.
Between 15 and 20 feet.
Oh my goodness, poor
So your
man.
body flew through the air between 15
Wow.
and 20 feet. Is that what your
Objection,
testimony is?
Shut up, Brooks.
Yes.
Sorry, I didn't rule on the objection, but it is overruled and his answer may stand.
Was David also struck
Wow.
by a vehicle during the parade?
Sí.
Yes.
His son was struck
He
too.
received injuries as well?
Objection. Relevancy.
Overruled. You may answer.
Okay, she's asking the relevancy of his son being struck by you. Bitch. Just incredible. Incredible.
Sí.
Yes.
Can you describe what your injuries were, sir?
Objection. Leading.
Overruled. You may answer.
You're sounding so
Sí.
Yes.
What were
stupid.
they?
Objection. Leading.
Overruled.
La fíbula
My fibula
y ligamentos.
and ligaments.
Your fibia was broken?
Objection. Leading. Speculative.
None of
Overruled
that.
as to both. The witness may answer.
Sí.
Yes.
And you had torn ligaments?
Objection. Leading.
Overruled.
You say that in the question before?
Sí.
Yes.
Wow.
And were those both in the same leg?
Objection. Leading.
Sí.
Sorry.
Yes.
Overruled. If we
Of course.
just wait when there's a
He is so
objection.
freaking rude.
I'm overruling it. It's relevant. It's not leading. The witness's answers may stand.
I mean, yeah, you overrule every objection.
And the jury will disregard the additional commentary made by Mr. Brooks at this time.
And you know what the beauty of this all is that not only do those of us who speak English get to hear his idiocy, those who speak in Spanish get to understand too. Wow. Unbelievable.
Judicial misconduct at its finest.
A judicial
And
misconduct.
which leg was
Wow.
that, sir?
Objection. Ask and answer.
Overruled. You may answer.
El pie izquierdo.
My left leg.
Did you have to have surgery on that leg?
Objection. Leading.
Overruled.
Sí.
Let's
Yes.
see what y'all
Just
trying
one?
What?
Dos.
Wow.
Two.
That's not gonna work either.
Mr. Brooks, you are advised to stop with the commentary.
No, I'm gonna say what I want
You
to say.
called this witness. I'm going to take a break right now and excuse the jury and this witness. All right.
What you doing is judicial misconduct.
Wow.
Judicial misconduct.
And the interpreter is telling Juan everything
You
that.
don't want the jury to hear the truth.
No, you don't want them to hear
That's
the
not
truth.
fair to the jury.
That's so funny. No, he's not letting the jury hear the truth of his sins. Wow.
They
This
have
is
a right to hear everything.
good gosh. This man is an idiot.
I'm not finna sit here and let you fix the trial because you don't want to tell the truth to the jury.
Fix the trial.
Mr.
That-
Brooks, please stop.
No, they ain't no please.
You are
nothing.
being disruptive.
Ain't
You
no
are being
please.
disrespectful.
You always
The
gonna
witness
find
may
some
step
reason to
down.
say somebody's being disruptive because they want the truth to be out there.
no, you're the only one being disruptive, you idiot.
You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be
Okay,
present
and
in this
Under
courtroom.
what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
what the fourth option that you made up? That's not.
She did not make up the fourth, not fourth, but fourth. Wow, people. Wow, wow, wow.
They want the truth to be out there. Man, quit it. You're supposed to be the
Mr.
judge.
Brooks, I'm advising you that continued interruptions will result in you forfeiting your right to be
Okay,
present
and
in this
Under
courtroom.
what law and
during
fact can you do that?
Illinois versus Allen.
Okay,
sir.
what the fourth option that you made up? That's not even in the law.
Mr.
Because
Brooks,
you can't do that.
I need to make a
By law, you
ruling.
can't do that.
I need to
You-
make
you
a
know you
finding. All right, I'm going to excuse everyone. Mr. Brooks is being removed from the courtroom. He will continue in the neighboring courtroom.
Yes.
Please make sure he has his objection sign and a pad of paper.
So is that
so that he can
So is that holding me in
meaningfully
contempt?
participate, and I will
Nope.
make a ruling when I.
so are you holding me
I'll
in
back up.
contempt? Is that civil or criminal?
You sound like an idiot now. Just stop. Ridiculousness.
Mr. Brooks has been removed to the other courtroom. The jury is not present, and the witness that was on the stand is also not present in the courtroom.
Actually, he is, Judge.
Oh, all right, then we'll have him removed. Thank you.
Oh,
Thank you
good.
for that clarification. I didn't see him seated. Oh.
Sorry about that thunder, but how good is it that Juan and his interpreter are still in there? They got to see the full-blown thing. Wow. Just amazing. Hopefully this thunder won't mess us up. Let's try again.
All the way back behind a couple of individuals.
Ooh.
So this morning, Mr. Brooks, prior to the court removing him, had interrupted the court approximately 10 times prior to 10:19 a.m. Then, of course, he was removed. This does not include the repeated commentary, either under his breath but still audible for the court to hear, the jury to hear, and witnesses to hear, related to a variety of topics, including subject matter, jurisdiction, misconduct by the court, disapproval with the court's rulings. This very last witness was a witness called out of order at the request of Mr. Brooks. As I know the attorneys are well aware, and certainly this court is well aware, under 906.11, the court shall exercise reasonable control over the mode and order of interrogating witnesses and presenting evidence so as to do all of the following: make the interrogation and presentation effective for the ascertainment of truth, avoid needless consumption of time, protect witnesses from harassment or undue embarrassment. That's all under sub 1. Sub 2, scope of cross-examination. A witness may be cross-examined on any matter relevant to any issue in the case, including credibility. In the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct examination. I frankly haven't exercised my authority under that particular subsection. I have generally relied upon sub 1. In addition, sub 3 says the following: leading questions. Leading questions should not be used on the direct examination of a witness except as may be necessary to develop the witness's testimony. Ordinarily, leading questions should be permitted on cross-examination. And during the cross-examination of this last witness, Mr. Brooks objected almost without fail, if not without fail, to every single question asked by the state on grounds of either leading or relevance. And then when the court overruled the objections, as time went on, it seemed to me that his commentary became much more audible. He was muttering under his breath and clearly showing disrespect for the court and the proceedings. In my opinion, they're baseless objections. Again, because this witness was brought into court on a subpoena that was from Mr. Brooks, served, of course, by the state to assist with him in that regard. But the state was well within its rights to ask leading questions. It's this court's opinion that the repeated interruptions by way of baseless objections is to disrupt these proceedings, disrupt the testimony of the witnesses, and in particular, Mr. Marquez. This court has been abundantly patient this morning, noting the repeated interruptions by Mr. Brooks, starting right away at 8:31. There were a couple of interruptions, continuing at 8:37. At 8:48, I think we had a total of 5 more at that point or so.
There was thunder.
At 8:49, and then of course at 10:19, this court removed him under its authority in Illinois versus Allen. I also had warned him, or at least at times I would give the jury an admonishment not really an admonishment, but an instruction. Please disregard the commentary by Mr. Brooks. It's been very apparent that any time this jury is brought in or taken out, Mr. Brooks begins making statements that are misstatements of the law, or generally his disagreement with whatever is going on at that particular time, accusing the court of either bias or misconduct, accusing this court of hiding information from this jury. This court is not doing any such thing. I will make a finding that based upon the conduct of Mr. Brooks, that he has forfeited his right to be present during the cross-examination and any redirect of Mr. Marquez. Mr. Brooks's conduct has been anything but respectful today. It's been disruptive. As this court was stepping off the bench, he made some type of statement about contempt. Are you finding me in contempt? This court is well aware that one of the permissible ways to handle a defendant who shows flagrant disregard in the courtroom for elementary standards of proper conduct is to find a defendant in contempt. However, I'm not dealing with a defendant who is out of custody. I'm dealing with a defendant who is in custody on very serious charges, including, if convicted, facing the possibility of life sentences without the possibility of extended supervision. It is my opinion that finding him in contempt is not really a viable alternative to this court. Frankly, it would, in my opinion, it would serve to give the defendant, let me restate that. In my opinion, if this court were to find Mr. Brooks in contempt, it would allow him to profit from his own wrongdoing because it would result in a delay of these proceedings. I would have to, of course, make certain findings. One of the possibilities for contempt is to hold him in custody until such time as he's willing to abide by the rules. That is just not something this court is willing to even do because it would delay the proceedings. I am aware that that is an option identified by the Supreme Court in Illinois versus Allen, but I would remind the parties once again that Illinois versus Allen was decided in 1970. Certainly the technology that we have available in this courtroom was not something available to the parties in Illinois versus Allen. We have a very new state-of-the-art courthouse that I am operating out of. I'm in courtroom 13. Next door is courtroom 20. These are just the room numbers that I'm referring to. As you can see, we have the ability to see and hear into that courtroom, and that courtroom has the ability to see and hear into ours. I will confirm with the bailiff and the clerk that the audio is working. I'm told that it is from my clerk. If I could also get verification from the bailiffs who are in that courtroom. But we have the ability, I have the ability, through that technology for Mr. Brooks to meaningfully participate. He does have, and it was provided with him when he was taken to that courtroom, the objection sign. I also instructed that he be given a pad of paper and a writing utensil so that he could write down his objections. Or if I feel it appropriate, I can unmute and hear what his objection is. But it's my belief that the use of my ability to mute and unmute will assist the proceedings so that it's orderly, that it is free from disruption as best as I can control it under my authority under 906.11 and my authority given to me and expressed by the U.S. Supreme Court in Illinois versus Allen. Although I'm making a finding that he's forfeited his right by his conduct to be present for the continued cross-examination and any redirect of Mr. Marquez, I'll also make an alternate finding that the technology that I've just described provides the functional equivalent of Mr. Brooks being present during this case. With that, I would like to have the jurors brought in. I'll have the witness brought. Back to the witness stand with the assistance of the interpreter, and the state can continue with its cross-exam of the witness called out of order, but on behalf of Mr. Brooks.
Yes, thanks for reminding us of that, and him.
And I am getting verification from the bailiff in the other courtroom through my bailiff here that the audio and video is working as it should. Would also like to point out that there are headphones at the table in front of Mr. Brooks should he choose to wear them. He has not worn them in quite some time. Previously made reference to needing it when he was in the other courtroom, so they are there and available. All right, would Mr. Marquez and Interpreter Ryan please take the stand, and we'll have the jury brought out. And just for the record, I will certainly let Mr. Brooks know he can ask to come back in when he's willing to abide by the rules of decorum and courtesy.
I don't think he's going to do any of that. I would just let him
The record
do.
should reflect the jury is being brought back in. Thank you, everyone. Please be seated. The record should reflect that Mr. Brooks is appearing from another courtroom. That should not affect the jury's verdict in any way. The state may continue with its cross-exam of this witness.
The state would have nothing further.
All right, Mr. Brooks, do you have any redirect for this witness? Mr. Brooks, do you have any further questions for Mr. Marquez? The record should reflect that Mr. Brooks is reading out of a book. He has not answered the question. I will ask one more time. Sir, do you have any further questions for Mr. Marquez?
He's playing hard to get. Okay, so hopefully this storm has not made it too difficult for us to hear and proceed. So now she's asking him if he would like to ask Mr. Marquez any further questions after his banishment to the bad boy room. Now, I have not watched all of this one, so I don't remember if he had anything, but I can picture him just, instead of just answering yes or no, maybe he'll just say no, or maybe he'll just say yes, but I could just hear him starting to spout off about nonsense like he always does. But let's see what happens.
Am I unmuted?
You are. You have been.
Yes. And we wait.
What's going on?
Do you have any redirect questions for Mr. Marquez? This is your opportunity to ask any follow-up questions that you have for this witness.
Are you really going to ask something? Wow.
Say something. I'm trying to see if the headphones on.
Nobody said anything.
It's supposed to be on the same channel.
Yeah, just hold up the time more.
Can someone say something from the other courtroom?
Any questions for Mr. Marquez at this time? It's your opportunity to ask follow-up questions. The state indicated it did not have any additional questions.
Nope, I don't got no follow-up questions.
All right, thank you. Then, Mr. Marquez, you may step down. Thank you for being here today.
Man, you know she's pissed. That's been a day. What an awful day for all of them. Bring that poor man and put him through all of that.
All right, I need to excuse the jury momentarily. Please rise for the jury.
He's so disgusting. I'm sure he's proud of himself.
All right, thank you. Be seated. Mr. Brooks, under Illinois versus Allen, which that case clearly tells me to do that, once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. The court is going to continue with the direct examination by the state of Detective Carpenter. I would like you to come back to this courtroom. Are you willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings?
I didn't do anything to be found held in contempt in the first place.
And you weren't held in
So are you
contempt.
willing to abide by the rules
Asshole.
of decorum and civility? I would direct your attention to SCR Chapter 62, which has been provided to you previously.
Does that say anything in there about me being held in contempt?
Oh, boy.
That does not, no.
So why have I been held in contempt?
I didn't hold you in contempt, sir. You are simply in a different courtroom based upon your disruptive behavior. I'm giving you the opportunity.
Has not been disruptive.
I've put my findings on the record, sir, and the record stands in that regard. I'm giving you the opportunity, if you can, indicate to this court that you will conduct yourself with courtesy and decorum. Are you willing to do that, sir?
Is Your Honor willing to tell me why I've been held in contempt?
I did not hold you in contempt, sir. I've already indicated that.
I would just say, you know what?
From the courtroom is like holding me in contempt.
No. Forfeited your
I
right.
didn't hold you in contempt. You were removed pursuant to the authority given to me by the United States Supreme Court in Illinois versus Allen, based on your disruptive behavior.
My behavior wasn't disruptive, Your Honor. The record should be corrected in that. And as I recall you stating before, or not you stating, but us having a conversation about Illinois versus Allen, for the record, at one point, I got the date in my notes that we had it where I said on the record that there were three options identified. And
Mr. Brooks, I'm not going to have a debate with you on what the law means and whether you understand it or not. I'm simply asking you whether you are willing at this time to abide by the standards of courtesy and decorum that are outlined in SCR Chapter 62 and that are inherent in the concept of courts and judicial proceedings, including making proper objections based upon the rules of evidence, based upon the rules of procedure, based upon the law, that you will not interrupt when you disagree with a ruling made by the court, and that you will generally conduct yourself with dignity and decorum.
But is it not my right? Is it not my right to object?
To what?
I'm going to ask Mr. Brooks one more time if he would like to come back to this courtroom and if he's willing to conduct himself with dignity, respect, and decorum.
But for the record, I don't consent to being called that name, and I never stated that I wanted to be removed from the courtroom.
All right, I'm going to mute Mr. Brooks. He is clearly not answering my question. And given his recent conduct, I'll indicate he continues to forfeit his right to be present based upon the prior disruptive conduct.
Yes.
I have given him 3 opportunities to answer the question, would you like to come back into the courtroom? And in other words, to reclaim his right to be present. He has chosen not to answer that. I understand he disagrees with the characterization by this court of his conduct, but my ruling stands, and the reasoning for my ruling stands. What I will advise Mr. Brooks is once the jury is brought back out and once the witness is back on the stand, I will unmute him so that he can properly object, and then I'll rule on, of course, any objections. I certainly reserve my right to use the mute function of the audio-visual capabilities that I have should that right be abused. So with that, why don't we have Detective Carpenter come on back to the stand. The jury is advised to come out.
So there you have it. What a big baby boy tantrum he threw. He doesn't think he's wrong. He really thinks, and the jury heard a lot of his nonsense. He really believes, I don't understand why, that it's going to make a difference and the jury's going to believe him. I have no idea why he thinks that, but that's just part of his delusional Darrell self. Well, hopefully this storm did not disrupt this too much. And I know I get excited and I stop and I have to talk, and sometimes I talk over it, but it's just, I'm a passionate, and I do my best to let them speak, but if I get passionate, that's just how I am. It is what it is. But at any rate, I appreciate you all. I love you. I thank you all for subscribing, for watching, for commenting. Hope you all have a wonderful rest of the week. And I will see you the next time. Don't forget to be kind to one another. Most importantly, don't forget to be kind to you.